Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Robert E. Timmerman Jr., and I'm just going to call him Bob. And Bob is an attorney here in Silicon Valley, San Jose, California. Has his own law firm, Timmerman, Silly, Coleman, LLP. And he specializes in estate planning, incapacity planning, and estate and trust administration. Bob is the managing partner and the founder of the firm, and he received a BA in economics and political science, magna cum laude from Boston College in 1975, and his JD or law degree, magna cum laude from Santa Clara University in 1980. He's an active speaker in the estate planning community, including the Jerry Kasner Estate Planning Symposium presented by Santa Clara University. He speaks for estate planning councils, bar associations. He's contributed chapters to books, including the California Estate Planning book published by Continuing Education of the Bar. And Bob has also participated in writing the rules of the court for the Santa Clara County Probate Court. So he knows his stuff when we're talking about probate. Now, on a personal note, Bob is quite an athlete. In 2009, he rode his bicycle 4,300 miles. That's a lot of miles across the U.S. and Canada. And in 2010, he rode his bike for 3 weeks throughout the mountains of British Columbia. He heli-skis every year, and he plays amateur adult hockey. So Bob is a pretty buff guy. Congratulations.
I don't know about that. Still trying to stay in shape.
Good for you, Bob. Anyway, today Bob and I are going to talk about the topic, I'm an executor, now what? And before we get started, I'm going to give the caution that I usually give our viewers, and that is we want you to consult with an attorney when you're involved with administering an estate. This isn't for amateurs. You really need that help. This is a huge topic. We're just going to cover some highlights. And we're discussing rules for administering estates in California. So Bob is a California attorney. I'm a California CPA. And there's even variations, I guess, from county to county and what have you.
There are local rules that can change the game slightly.
Yeah, okay. Anyway, so the laws are different in other states. You do need to consult with a local attorney when you're dealing with these matters. Bob, thanks again for joining me today.
Mike, always a pleasure.
Okay, thank you. Well, let's get started. What is probate?
Mike, that's probably the simplest way to answer that question is to break it down into its components. It is a court-supervised process of transferring wealth from a decedent to those that are entitled to it. So when you look at it as court-supervised, that means that a judge will be overseeing the administration. Generally, there are petitions filed with the court. Court orders are obtained. Ultimately, an order of final distribution is obtained from the court, and the estate is then distributed to those that are entitled to it. The key word, though, is court-supervised.
And now, it's not really in my questions here, come to think of it, but it just came to my mind. The settlement of liabilities is a pretty important part of this probate process, isn't it?
Well, anytime you have an estate, most decedents have some sort of creditors that are outstanding. So when there is a probate process, you have to give notice to all known and reasonably ascertainable creditors. Those creditors have a certain period of time to file claims. The executor then the person in charge of the estate, then has to examine the legitimacy of those claims, determine whether or not to accept them, to deny them, to compromise them. So it's not just settling the assets, it's handling the claims and liabilities.
And in a sense, though, as I understand it, that's really one of the important sort of advantages in a way of probate is that you can actually sort of cut off the liabilities at a certain point if you give them proper notice. Isn't that right?
You know, not so much anymore, Mike.
Oh, really?
Because in a trust administration, You can opt into
Yeah.
a shorter creditor claim period.
Mm-hmm.
The creditor claim period in a probate administration is 4 months
Mm-hmm.
from the time that letters are issued to a personal representative. In a trust administration, so as an alternative to a will or dying intestate, meaning without a will, you can either opt in and shorten the creditor claim period in a trust, or you can wait the 1 year statute, which cuts off all claims cuts off most claims after a year.
Okay. Well, I'm glad we talked about it a little bit. We're going to have another interview, by the way, folks, about when you're a trustee. So I hope that you'll keep an eye open for that. And these will all be posted on the internet at our website, financialinsiderweekly.com. Okay, well, let's move along. Let's see here. If the decedent had a living trust, does that automatically mean that no probate is required?
In most cases, the answer to that is yes. And I won't say automatically. When an individual passes on and they had a trust, that trust was created during their lifetime, and the question becomes one of funding. Did they transfer their assets that otherwise would have to be court supervised under a probate process? Did they successfully transfer those assets into their trust? If they did, those assets do not go through any sort of probate process.
Mm-hmm.
But as more often the case, they tend to leave some assets out. A good example would be they put their home into their trust, they did a new deed, they titled it in the trust, and some years after the trust was created, they refinanced the home. Many lenders oftentimes will require the resident owner to pull the property out of the trust to do the refinance, and then they forget to put it back in. So it's not uncommon that we may have a concurrent trust administration as well as a concurrent probate administration. And there are shortcuts to try and shorten that process in appropriate circumstances, but not all courts are readily willing to grant those shortcuts.
Okay. So you do quite a bit of estate and trust administration, I know, because I've worked with you on quite a few of those. So is that a common problem that you see of assets not being transferred to the trusts?
I'd say it occurs in almost every estate that we administer, that there are some assets that inevitably will not be in the trust. And so what we initially try and do is develop evidence of what was the intent.
Mm-hmm.
And if we can show that through a general assignment and perhaps a pour-over will, that the decedent really wanted his assets to stay out of court supervision to make it more efficient, both from a cost and time point of view for the family, many courts, many local county courts are willing to grant the relief and order those assets as part of the trust without a full-blown probate.
Good. Now, so maybe this is a related question, but do all estates have to go through probate?
Oh, indeed, no. In fact, most estates never go through probate. The vast majority of decedents have their property owned in a variety of different ways. Assuming a single person, not a married person, they could have joint tenancy assets, they could have retirement accounts that have a pay-on-death beneficiary. All of those type of assets don't go through probate. They're not subject. It's only the assets that stand solely in the decedent's name that we may have to go through probate. We recently passed a statute in California that increases the size of an estate that can avoid probate from $100,000 to $150,000.
Okay.
That'll be effective on January 1st of 2012. But as a result, if you had some bank accounts and maybe some stocks or bonds that were just in your name, but the total value was under $150,000, again, we just have to wait 40 days post-death, file an affidavit with the institution, and collect the asset.
Okay.
So most estates honestly don't go through probate.
Mm-hmm. Okay. Well, part of the reason, and that we even talk about this and the area of probate in general is that a lot of people think that probate is a very negative thing, that it's something to be afraid of, or they're sort of terrorized by the thought of this process. And so, we're trying to say that probably there's a good chance anyway that you won't have to deal with probate anyway. Of course, there's certainly ways to plan around probate.
Sure. And I think the point is well taken, Mike. Any individual that owns any amount of estate assets, a house, some bank accounts, ought to at least consult with an attorney to discuss, what are my options? What do I need to do? Obviously, the larger the estate, the more likely that we'll create a trust or do something to keep us out of court supervision. Because probate is still a court-supervised, tedious process, and it's expensive, much more expensive than a trust administration, because the fees are based upon the size of the estate that is subject to probate, as opposed to the amount of work that may be necessary to get that wealth transferred. So taking a look and planning, and you can plan using joint tenancy, you can plan using pay on death beneficiaries, you can plan designating beneficiaries or retirement accounts. It may be a little more complex and it may be piecemeal instead of global, but it can be done.
Sure. Okay. Let's see here. A husband who had a will dies. He leaves all of his estate to his wife, and all of their property was community property. So is a probate required?
A probate is optional in that circumstance. And in fact, in most cases, there would be no probate. California law provides that as between married couples and as between domestic partners, registered domestic partners, that property that is community property, that is acquired during the relationship by one's time, labor, effort, or skill, is not required to be probated. We can do what's called a spousal property petition. It's kind of a one-stop into court. You get your court order confirming that all these assets belong to the surviving spouse, and it's in and out of court, and you're done. Spousal property petitions are quite common. There are advantages to them as opposed to using joint tenancy. So again, I think the key point is plan that estate. Don't let it happen, because when things happen, we're trying to pull things out of the fire afterwards in order to make it more efficient for the family.
Yeah. Okay. What are statutory probate fees, and are they really horrific? And can any other fees be charged by an attorney or the executor?
Statutory fees are based upon the size of an estate probated. And it's the size of the gross estate. So let me give you an example of why they can be somewhat unfair. Suppose somebody owns a house with a fair market value of $500,000, but they have a mortgage. Let's say they're not underwater in this economy. They have a mortgage of $350,000.
Yes.
So their net equity in that property is $150,000. But the fee is based upon the gross value of the property. So the fee is based upon a $500,000 asset, not a $150,000 net asset. And those fees are based on a sliding scale. They're a percentage of the estate. So it's 4% of the first $100,000, 3% of the next $100,000, 2% of the next $800,000, and then it reduces thereafter 1% up to, I think it's $10 million, and then it goes down from there. But the bottom line is percentages of the gross value can be a fairly sizable amount. On a $500,000 estate, you can see how those fees add up pretty quickly.
Okay.